No, Prescott.
Thank you very much. Judge, may I seek to end by addressing 5 points before your Lordship, and hear from me.
Yes.
But firstly, amongst the submissions made by counsel this morning on behalf of the appellant was that there was no policy in the respondent's Port Authority regarding re-employment or engagement of persons who had been incarcerated and returned to work. And therefore that the circumstances attending on Mr. Daban's application were not taken into account. But we invite your attention to the memorandum set out at page 281 of the record, which speaks to a concern expressed by the Port Authority at paragraph 3 of that memorandum, which showed that among the circumstances taken into account were that, quote, had he been reinstated, that is, Hippolyte, his position on the roll would be at 112 as port follower. There is also another reference to the trade union's word being essential to any determination about these employments, and that can be found in 2 places, at page 44 of the record, in the affidavit of Elva Stuart Toussaint,
Yes.
you would find her saying, pardon me, did I say 44? Yes. That the registration committee, paragraph 45, and the union were necessary parties for consultation. Otherwise, they could not act. The language uses the respondent could not act without reference to the union or bypass the registration committee. To do so would be to act unreasonably and inequitably in relation to the union and its members. We ask you to interpret that as saying that it was essential that the Port Authority take, among its circumstances in considering Mr. Daban and Mr. Hippolyte's applications, what are the views of the trade union and how it would impact other workers of the Port Authority. The same sentiment is repeated in paragraph 46 on the same page. And you will find also that in the affidavit of Peters, Carlisle Peters, at page 275, and in paragraph 8, once again speaking about Hippolyte, he said, unlike the applicant, Hippolyte had made himself immediately available for work, and representations were made on his behalf by the recognized majority union of the respondent. I made those references to say to the court, to submit to the board, that it would be unreasonable to have expected the Port Authority to act without reference to the trade union, both at the time Mr. Daban sought employment and Mr. Hippolyte. Because one could not simply slot them in either where they had once been in their previous employment.
But could the trade union, under this agreement, require the employer to act contrary to its constitutional obligation, assuming it had one?
The answer may well lie in whether it is correct to say that these were private functions. If they were, the trade union must boldly say that you may
yes, but
not.
if it wasn't,
if it were not, the court would hold that the constitutional obligations trumped.
override. So it would be no answer to say we had the trade union wouldn't give us consent. Obviously, you're entitled to consult, but I would have thought, but not.
May I remind you, milady, several times before, during 1969 to 1980 and on to 1990, there simply was no need to consider whether there was a constitutional motion. Time was not ripe for any such motion. It required Mr. Hippolyte to come onto the scene in 1990. I trust that assists with my answer to your question.
1980, is it?
There would have been no opportunity until 1990 for Mr. Daban to properly contend that any right of his had been infringed, any constitution. He required a comparator, and that only came on.
Is there any Trinidadian jurisprudence on that particular point?
The point being
that you cannot bring a claim for discrimination unless the comparator is there at the time when the employer committed the act of alleged discrimination. Has this been argued in?
The question doesn't seem to have been arisen. The courts have proceeded on the basis that discrimination requires two persons, each of whom had been treated differently. I hope I'm not being flippant in answering that.
No, well, I think that the situation is this. Until you've got a comparator against whom you can say, or in relation to whom you can say he's received better treatment than I, then the question of discrimination doesn't arise at all. But I think my lady's question is directed more to the question, once you've discovered a comparator and once you can assert a claim of unequal treatment, is it possible for you to trace back that inequality of treatment to an earlier period, before the arrival of the comparator, in other words?
This morning, it has been put to council, and I agree with you, it is an open-ended sort of constitution, which might allow for that kind of finding or ruling. However, the thing that might matter most might be the extent to which you have delayed and the reasons for which you have delayed doing that.
Yes, but in specific reply to my lady's question, can we take it that there's no Trinidad and Tobago
We are unable to.
Jurisprudence that touches directly on that question?
We are unable to refer to any Trinidad case or Trinidad or Tobago case that speaks to that.
Thank you very much.
We've gone along with all others on how it is to be treated. The second point, Millard, it has been said here that there was a salary difference of $1,500 between permanent workers and temporary workers. And that is not going to be ignored by anyone in contemplating whether Mr. Daban was justifiably treated or not. I mean, that's a substantial amount of money to be claiming, especially at that time. It is our submission that firstly one must observe that the distinction between temporary and permanent workers. And there was no time between 1969 and 1990, and in 1990, that Mr. Daban could have claimed to be a permanent worker. He was not. When he was being compared to Mr. Hippolyte, they were both being compared as temporary workers, and therefore the salary ranges would have been the same. It must be remembered that Mr. Daban had said very forcibly, I have not suffered any loss by being placed in the position that I was in 1990. I got the same jobs as other people who were temporaries, and therefore I got the remuneration to which I was entitled. There was therefore, it is therefore our submission that this board ought not to place any emphasis, relevance even, on the distinction which has been made twice in the appellant's case, that there's a $1,500 difference between the remuneration of permanent and temporary workers. I do confess that Mr. Daban, if I may draw your attention to that briefly, in his affidavit in support of the motion, a very brief statement at page 20 to 21 of the record, says at paragraph 2 that he had read the statement of facts which accompanied the motion, and he verifies and confirms those facts. My submission is that this does not make it evidence on oath or at all that temporaries earned less money than permanents. It had been said in the motion that that is so, and it was repeated in the judgment at first instance that that is so, but it never appeared anywhere else subsequently.
Yes.
So far as they were both temporary workers, therefore, it really is immaterial to have put forward the $1,500 difference. And at most, it might prejudice some judicial minds. Out of courtesy, I say it could not be in this
Well, we'll try to hold ourselves above that.
Indeed, I'm so
Thank
grateful.
you.
Equally, Millard, it has been submitted that Daban would not have been entitled to a gratuity. I hope I'm fair in saying that. But that is not so. Millard, the collective agreement which is before you at page 57 of the record, Article 3. Distinguishes between regular workers, registered workers, and others, the workers on the roll. Both Mr. Daban and Mr. Hippolyte, when they returned, were placed on the roll. The Article 3 goes on to say, the following provisions, the last 4 lines, shall not apply to workers on the roll: work guarantee and pension.
Yes?
So that gratuity, Millard, remains within the reach of any worker, be he regular or temporary.
That's page 83, is it, Mr. Prescott?
I was looking at page 57. Is there something on page 83?
Well, Article 31.
Yes,
gratuity
Article
benefits.
31, thank you, yes.
So your point is that
Article
gratuity benefits have not been excluded
in relation,
from workers on the roll.
much obliged to you.
Very well.
That is correct. And although it might be implied that Mr. Daban, therefore, might have become entitled in the long run to a lesser gratuity, the answer is Mr. Daban rules that out. He says, I was always in employment. I got the same money that I would have temporary.
So there was no evidence before the Court of Appeal that the gratuity was different for somebody on the temporary role as opposed to the port followers.
And in accepting that, I'm saying my stress is on the word evidence. It formed part of the submissions. It was said in the motion. And Mr. Daban simply said, I verify those facts. But to me, that would not have sufficed.
So he was not making any complaint about the gratuity.
He made no complaint about gratuity.
Thank you.
I'm much obliged to you. I next move to what appeared to be the submission of counsel in relation to the Court of Appeal's finding about material differences. And that is a reference to the Court of Appeal at page 478 of the record. It's said in paragraph 40, pardon me, a combination of paragraphs 39 and 40, that there is a material difference between the respondent and his comparator, which is relevant to the outcome of the appeal. And the reference is to the fact of the status of the employment prior to incarceration. That is in the last sentence of paragraph 39. The consequences of the appellant's decision, however, were different for the respondent, since he had been employed as a permanent worker prior to his incarceration, and you will recall that was 1963 or thereabouts, and therefore was not reinstated. This discloses a material difference between them, which is relevant, and then the court went on to treat with outcomes. Now, my Lord, acknowledging that in this court's decision in Webster, there is this discussion about similarity and difference and comparability. All we are making a point of is that insofar as the Court of Appeal found that there was a material difference between the two men, the two comparators, it would really be incumbent on the appellant to have demonstrated A, that there was no difference, and B, if there was, we are submitting that he has not been able to. Only finding as to material difference remains in the Court of Appeals ruling.
Yes?
However, for emphasis, there were obvious differences between them, and that is to say, insofar as during 1969 to 1990, there was no comparator until Mr. Hippolyte came onto the scene. That is a difference which had to be taken into account. The Court of Appeal took that into account as well. Never at any time between 1969 and 1990 to be compared with Mr. Hippolyte. First evidence of infringement, if any, or of which he could have complained, therefore arose at the point of Mr. Hippolyte's engagement. I move to the next point. Council had submitted that the input of the trade union goes to reinstatement of a worker and not re-employment. Once again, I'm going on the note that I have taken. Correct, but if it is that he had said so, I think I have made it clear that the Port Authority is obliged to treat with the trade union, and in particular on matters of reinstatement, because reinstatement, as we all know, means going back to 1960 in the case of Mr. Daban.
Well, I think we've got the point that reinstatement has an impact on other members of the union. And that's the reason that they would want to express an opinion about it.
So that I now move to the appellant's case before you at page 500. Let me find mine. You have it there? And I'm dealing with Romans 3, page 500. If you just bear with me, please, no grounds of
I'm so sorry, I'm
sorry.
having difficulty hearing. Which page do you want us to go to?
I do mean page 500.
500.
Grounds of appeal. Do forgive me.
Ah,
Do forgive me. Thank you very much for bringing it to my attention.
thank you.
And in Romans 3 of those grounds, it is contended it was wrong to find that the treatment afforded to Hippolyte and the appellant was the same, and then it goes on to speak to the offer of temporary employment. And it says as follows: as stated at 2 above, Mr. Hippolyte was re-employed on the same role, that is, the portfolio's role, that he was employed before his imprisonment. The appellant, on the other hand, was not re-employed as a permanent worker, which position he held before imprisonment. And we are contending that that is the wrong approach to determining as between the two men. What has been made clear is that there was a subcategory of workers called temporary workers, of whom, or among which, port followers and temporary workers and retrenchees and seasonal workers were all one and the same, temporary workers. So that it could not be said justifiably that in assessing the positioning of Mr. Hippolyte and Mr. Daban upon their re-employment, that Mr. Hippolyte was re-employed on the same role that he had before, and Mr. Daban was not. Mr. Daban could not have been considered for the permanent role, which was his 1964 position. The port had before it 2 persons who applied. Their background was well known, and they chose to place them on the temporary list. In the case of Mr. Hippolyte, they placed him at the bottom of the port followers role. In short, he would be the last person to be called there. And Mr. Daban was the first person on the temporary role. He would be the first person to call there. And in any event, Mr. Daban says, at the end of the day, it made no difference between us in terms of the jobs that were offered to us or the remuneration that we got or the number of times that I was called out to work. I was not in any sufferance in those circumstances. So that I only need to say we should be reminded that what Mr. Daban sought by way of relief was to be returned to his position as a permanent worker in 1992. A permanent worker. We say he was not entitled to that. We say that he would not be permitted, after consultation with the trade union, to have returned him to that position. He could only be considered in 1990 or in 1980 when he got employment in terms of what was available on the temporary rule. He could not be considered for a permanent position. But his case was based at all times on relief as a permanent worker in 1992. In 2004, when he filed his action, once again he claimed to be entitled to be registered as a daily paid permanent worker. And that too was not available to him. The reliefs, I think you've been referred to them many times before, and they do not support any other interpretation, but that Mr. Daban has always sought to be restored to a position to which he was not entitled. Okay? Well, unless there's some other matter which might be of...
Yeah, thank you very much indeed.
I'm grateful to you.
Mr. Sushan, do you follow?
My lords, my ladies, I do not believe I can be of any further assistance than Mr. Prescott has already given.
Well, thank you very much for the assistance that you've unquestionably rendered already. Now, Mr. Poole.
My lord, yes. My lords, my ladies, I think I can keep my reply to 4, hopefully fairly brief points. First, it was suggested by my learned friend that the courts below found only that the appellant was within the jurisdiction and did not go further, and particularly did not find that he was available for work. In my submission, that's a difficult submission to make, given the finding that you see at paragraph 34 on page 384, that the appellant persevered in his quest to be re-employed, combined with the fact that the evidence is that he was only engaged in temporary casual work with the council between 1969 and 1980. And there's no reason why he would not have been in a position to take up re-employment had his representations met with a positive outcome in those years. Second, the delay on the part of the appellant, and I said I'd come back to this if I needed to in reply. I say it is not correct to say that there has been no complaint by the appellant. And if I can break down the period, firstly dealing with 1969 to 1980, the evidence was that the appellant made repeated representations to the respondent to be re-employed, and the reference for that is paragraph 12 at page 262. He was, as we know, re-employed in 1980, and I can usefully probably pick up the chronology by reference to the first instance judgment at paragraph 9, which is on page 370. Reference made there to the applicant persevering with his objections to being treated, a meeting with the respondent's divisional manager of HR, Mr. Yates, and the deputy manager, Mr. Lucas. We know that Mr. Hippolyte was re-employed in November 1990, just following through the chronology. It was 2 years after that that this meeting took place. It was 1992 between the divisional manager of HR and the Port Authority divisional deputy manager. And we see that at paragraph 7 at page 13. And that prompted a letter, and that letter is the letter that you see at page 24. It's a letter of the 30th of April 1992. That's a fairly important letter as far as the appellant's concerned, because that is a letter that stated that the appellant was registered and confirmed as a lift operator. Now, he says he wasn't aware of the contents of that letter until 1994. The reference for that is paragraph 8 at page 14.
Can we just understand what number page 24 does mean, Mr. Poole?
Well, my lord, yes.
Can we just look at it altogether? You're hereby informed that Mr. Daban, temporary lift operator, is now confirmed in his post. And I wondered at first what confirmed meant, particularly because the heading is registration. Did it mean confirmed as permanent? Answer, in your statement of facts and issues, no. This means confirmed as temporary. Do you agree?
Well, I agree. I think I'm contrary to the way it was argued below, because a lot of weight was attached to this letter in oral submissions in the Court of Appeal.
Yes.
Because the interpretation that was placed in that letter in the Court of Appeal is that what this meant was, in fact, this was recognition that he was being made a permanent worker as of April 1992, and there was a lot of debate about that in the Court of Appeal. I say,
Nevertheless, you have both signed the statement of facts and issues, and I found it very helpful, because I was puzzled about this letter, to read paragraph 16, in which you join in accepting that is now confirmed means is now confirmed as a temporary forklift operator.
my lord, that is, as I say, that's my interpretation. That's why the statement of facts and issues.
Very well.
Yes. The reason it is probably worth noting that that's not how it was argued in the Court of Appeal. It is perhaps for this purpose. It's not really how it was understood by the appellant at the time, because we can see that from persistent representations then being made, effectively asking the respondent to act upon this decision. And in just following through the chronology, we see the letter at page 25 and the next page in the electronic bundle. It's the 18th of March. Reference there being made to a decision being taken to reinstate the appellant.
Well, we needn't pursue that because it was all in error.
My lord, yes. And all I'm seeking to do at the moment, and I won't take up too much more time, is just try and follow through the chronology to meet what is said against me, which is, I think it was put that the appellant really sat on his rights and didn't take any action.
Well, I mean, when you do show us bits and pieces of, well, he complained then, and there was a meeting in 1992, you can't really blame us for sitting back and saying quietly to ourselves, and Mr. Poole is talking about the period from 1969 to 1992. So to point to the odd protest in a period of 23 years may not get you very far.
Well, my lord, I put it higher than that. It's not the odd protest. And in fact, the contemporaneous documents suggest otherwise, because even the respondents' officers accept that there have been persistent requests made by the appellant, and perhaps the best reference for this is the letter at 251, which is a letter in 2003, addressed to...
yes, well, we read that. I mean, persistent from 1969 to 2003? I doubt it, Mr. Poole.
Well, all I can do is point to, between 69 and 1980, we have a finding that there were continued representations being made. Post-1969, there were regular meetings and representations being made, and using the language of the Port Authority itself, referring to it as persistent. And there's perhaps a more colourful language used at page 25, which is, again, the respondent's own letter, perhaps slightly exasperatedly by the writer, for the umpteenth time, can I now have a response so that a decision can be taken in this matter? So it is quite clear in my submission that when one looks at the contemporaneous documents, the picture that is quite clearly painted is of the appellant complaining, the respondent not dealing with it.
Well, I don't know that that's necessarily the picture that emerges. There was obviously a fair amount of confusion, because this letter of January 2003 refers to a persistent request to be registered, but the letter at page 24 shows that he had been registered.
Well, my lord, and this goes back to my Lord Wilson's question of how you interpret that earlier letter, because...
Yes, but it's now agreed. We don't have to question that, but the parties have agreed.
Yes, but this is why perhaps it is relevant to explain this correspondence, because the parties were operating on the basis that a decision had been made to reinstate. But then I think what is said by the respondent is that needed approval by the union, so the decision was never implemented. That's certainly how it was put in the Court of Appeal. But I take my Lord Kerr's point. But
In fact, he never was reinstated, was he?
No.
No.
And neither, it would appear,
And
Mr. Hibbert.
on the proper interpretation of the letter on 24, page 24, it was never intended to reinstate him. It was merely intended to register him, which makes the letter on page 251 inexplicable. Why should he be persistently claiming to be registered when he had been registered in 1992?
Well, the registration refers to him being recognised as a permanent employee. That's the terminology is being placed on the register of employed workers.
Well, register at page 24 refers to temporary employee, but register on page 251 refers to permanent. Is that what you're saying?
Well, my Lord, the letter at page 24, that's confirming him in his post as a temporary lift operator. That doesn't talk about registration.
Oh, I see.
It is registration, and I think this is common ground between us. Registration is talking about your name being placed on the register of permanent employees, and that's what his complaint has always been throughout this time, which is effectively, leave aside what date he says he should be recognised from, the complaint is, I'm a temporary worker, I should be a permanent worker. And that is what I say.
The registration means registered as a permanent employee.
Yes, my Lord.
I see, all right.
Rather than being on the rolls. And then, just
on that,
my Lord, yes.
Can you help? Why is the letter headed registration and confirmation?
My Lord, I can't assist with that. And perhaps,
Right,
and that, well, I think, and that's where some confusion, and hence I anticipate my Lord Wilson's question about page 24. But all that letter is doing, in my submission, is confirming the appellant as a temporary operator with effect from the date it says, namely May 1992. But we then get up to 2003, and then we know from the evidence there's a round of promotions that the appellant is unsuccessful for. He then files his constitutional motion in August 2004. And what I hope to have demonstrated by going through the contemporaneous documents and some of the findings below is that far from sitting on his rights, the appellant was, I hate to use the word again, but I do persistently, inviting the respondent to recognise him as a permanent worker. And so, in my submission, there's no undue delay, and certainly no delay that should mean that he should be shut out before this board pursuing the constitutional claim. My third point goes to the point I said I'd come back to my Lady Arden on, which is the gratuity point. And there's two aspects of this. First, I think in answer to, my learned friend, in answer to a question by my Lady Arden, might have suggested that the Court of Appeal, there were no findings by the Court of Appeal about gratuity. The Court of Appeal found, and this is paragraph 42, page 479, that as a consequence of not being a permanent employee, the appellant would lose out on, and they said, gratuity, pension and financial benefits, as compared to a temporary worker. Now, my second point, I think probably the Court of Appeal is wrong in that respect, and this comes back to the question I said I would take some time to find if there is any evidence, which is namely, are temporary workers entitled to a gratuity? And I think I join issue with my learned friend on this, or rather I agree with what he said, which is the gratuity provisions apply to all members of workers on the rolls, so all temporary workers. So it matters not whether you're a port follower or whether you're a temporary worker on the temporary roll, you are entitled to a gratuity. And I think that not only...
But that's not what you said this morning.
Well, my Lord, I hope I didn't... I think I said I would... I wanted to... I think I said I wanted to take time to confirm.
But in any event, does the gratuity fall out of the case now altogether?
My Lord, no. But it perhaps waters down the submission I was making, because what I do still say is that there is an important distinction between a port follower and a temporary worker, and this goes to the availability of work, because we know from the collective agreement that you were taken to in my learned friend's submissions a moment ago. Page 83 was what my Lord Wilson specifically pointed to, which talks about the gratuity provisions. It's calculated on the basis of effective years of service. Now, for a temporary worker, that means 1,080 hours a year. Yes. So what I say is that the amount of work obviously impacts on the amount of the gratuity, but I recognise that doesn't take me too far in this case because the appellant himself recognised that there wasn't any shortage of work. And so on one view, it may be said, well, if there's no shortage of work, he would be accruing the same amount of gratuity as he would be whether he's on the portfolio's role or the temporary worker's role. Now I say that may be right. There wasn't an investigation below because this is a matter that does go to compensation. And it would be a matter that would have to be, if the finding of the board was he was entitled to be a port follower, whether it be 1969, 1980 or some other date, then there would have to be an investigation as to what impact that would have had on the gratuity he received when he left, medically retired, and what he would have been entitled had he been a port follower from, as I say, whichever date it may be.
But
so
I'm understanding what you're saying about this. You're saying that might be a matter which, if you succeed in the appeal, would have to be investigated,
my Lord, yes.
Going to remedy, but doesn't affect the case as to whether there is liability established under Section
My Lord,
40.
that's right. And it's really a point to clarify, and I hope I didn't put it too high or incorrectly earlier. I think there's a suggestion that there were 2 points on the gratuity, one about the number of hours and one about the gratuity itself. The suggestion might have been that temporary workers on the temporary role aren't entitled to one. And that's the point I just wanted to check, and that's the point that I'm now saying I think that's not right. All temporary workers are entitled to a gratuity.
Just on the Court of Appeals judgment at, I think it was paragraph 42.
Yes.
I mean, it does look as though they made a slip just in their recitation of the facts, but it doesn't affect things because gratuity comes out for both Mr. Ippolit and the appellant.
My Lord, that's right. That's right. Sorry, my Lord, if I may just tell you that. Sorry, I'm grateful. It was just some instructions on that gratuity point. Finally, my Lords, it's my fourth point. On the comparative question, there's a reference in our written case to what Lord Nichols said in the case of Carson, which you have in the bundle under tab 15, about the sameness question. Really just for your Lordship and your Ladyship's note, what Lord Walker says at paragraph 63 is, in my respectful submission, illuminating on the question of comparators, because what is said there, it's page 913 of the record, one of the most powerful criticisms of a rigid step-by-step approach based on comparators is that given by Lord Nichols in the case of Shamoon, and then it says, Lord Nichols demonstrated the step-by-step approach was liable to obscure the real issue, which was why the complainant has been treated as he has been treated. Until that question is answered, impossible to focus properly on the question of comparators. And as Lord Nichols observed, sequential analysis may give rise to needless problems. And then there's a quote from Shamoon saying, employment tribunals may sometimes be able to avoid arid and confusing disputes about the identification of the appropriate comparator by concentrating primarily on why the claimant was treated as she was, which nothing there inconsistent with what is later said by Lady Hale in the Webster case, but perhaps they're focusing more on the comparator question. Unless I can be of any further assistance, that's all I had by way of reply.
Thank you very much indeed, Mr. Poon. We're very grateful to counsel who have addressed us and those who have assisted behind the scenes, so to speak. The board will take time to consider its judgment. The court is now adjourned.